Charges come first, evidence comes later. In a criminal case in Louisiana, to be convicted, the DA has to prove beyond a reasonable doubt that you committed the crime. But what about an arrest? Well, that's a much lower bar, and that's probable cause. And then to even pull you over or ask you questions or detain you, they've got to have reasonable suspicion, which is even lower than that. So what happens if there's not enough evidence? Well, the police and the DA can work together to investigate and find out more about the case. What happened? They can interview witnesses. They can test any types of drugs. They can do ballistic reports. They can do autopsy reports if someone has died. These are all things that they're allowed to do because once they arrest you, they have a certain amount of time to bring charges against you formally. Once they do that, then they also have a certain amount of time to bring a trial. These are all things that your attorney would understand and can file certain motions to make sure that it moves quickly and that your rights are protected. There are speedy trial motions. There are ways to get the bond taken off if you've been in jail too long. There's even ways to get you released from jail if they haven't brought the charges in enough time. So make sure that if you're charged with something, even if they don't have evidence in your mind, that your attorney knows all the details and that your attorney's there fighting for you to make sure that all your rights are protected and perhaps get you out while you're dealing with these charges. So if this happens to you, call us at the Bradley Law Firm. We can go through your rights and give you all the details of what's going on and help you win the case.